sheets before, but now I've got them lined up as you would see them. I actually prefer for you to do your issue sheets by hand, even if you're typing your exam. I think your thinking process is better when you do that. And I really like the idea of seeing the big picture, seeing the entirety of the problem laid out in front of you. Whereas if you have it on your typewriter or your computer, you're having to go up and down. Okay, so what each of these issue sheets is an IRAC. Okay, so issue, rule, analysis is the facts that you're going to put under each one of these. And then before you leave the sheet, you should write a conclusion heading. Okay, so it's an IRAC, issue, rule, analysis, conclusion. Issue, rule, analysis, conclusion, etc. Okay, so the issue, former testimony. The rule was both the statute and the Hanna case. Statute test is the jumping off point, and then the Hanna case test is going to be the one you actually reason about. And here it zoomed right in on the one word, motive, and gave you a test for that. So now you're going to go back to your facts, or remember your facts, because mostly you'll probably remember them, and put in the facts that apply. Now I already kind of did this when we went over them before. Substantially similar. Remember that Watt was the only evidence that the prosecution had. So when they had to dismiss the case, they had a very strong motive for cross-examining Watt rather than dismissing the case. Furthermore, his testimony indicated that the police had coerced him into perjury. So the police, the prosecution could have gotten in trouble for using fraudulent testimony. Okay, so there were all sorts of reasons for the prosecution to attack Watt's recanting. And as I said, the reason that they didn't was they didn't want to make the situation any worse than it already was. Okay, so they did have a substantially similar intensity of motive at the trial. Now the defendant, Rock, wants to use this in his civil suit against the police. Okay, and they are going to be able to. And the proceedings were similar. They're not so similar. That was a criminal trial, and this is a civil trial for various torts that the police committed against Rock. He wound up spending 9 months in jail pre-trial. So that's a lot of harm to him by their falsified evidence. Second issue is the residual hearsay exception. It's Federal Rule of Evidence 807. It has a four element test in the statute, and then the Bryce case zooms in on the first the first element in the statute, trustworthiness, and adds a test to that. 5 factors: spontaneity, consistency, no motive to lie, why Watt is now unavailable, and the voluntariness of the statement. And as I said verbally, you would now go back and write facts next to each one of these. Spontaneous, yes, he was talking to his lawyer off the cuff. He sounded upset. He was umming and erring. It was not a contrived statement. Consistent, it was similar to what he had said at trial. The voicemail message was similar to what he said at trial 9 months later. So the consistency, no motive to lie. He was trying to get advice from his own criminal defense lawyer. He's dead, and it was voluntary. Nobody coerced him to call his lawyer and ask for advice. So this works in our favor too. And then the last one, the issue with statement against interest. The rule is 804, Federal Rule of Evidence 804B3. And it has a two-element test in the statute. The second one involves corroboration of the statement, and the Cabrera case zooms right in on corroboration and gives a 2-part test: the time and the spontaneity. And here, as I said before, the time was very, very short between the grand jury testimony and the voicemail message to the lawyer, and the spontaneity. Again, similar to spontaneity here, it was not a rehearsed statement at all. So when you have this laid out, you can see sort of the all of the problem. Okay, you can estimate your time better for writing it because you can see everything here. You can work in all the facts so that you have literally an outline of your answer in IRAC form. Okay, your answer would then, I'm not going to do it because I don't know how long this tape is going to hold, but your answer would then be this issue on top of this issue on top of this issue. So your macro organization for your answer would be the three things stacked on top of each other. Okay, so this is the classic simplistic organization that one PT in every bar exam is usually this kind of 3 cases, 3 issues, or something similar, 3 separate issues. The other one on every PT since 2007 has been a mothership, which is what PTA was, and that is a much harder thing to suss out. And we're going to spend some time on that in a separate video. Okay, so that's PTB.